अपनी टफलॉ पंजाबी
पढ़ने की जरूरत नहीं है बेटा,
Okay.
सबको पता है।
Okay. So over to you, ma'am. Thank you, ma'am. Thank you.
So, dear participants, it's really a privilege for me to be one among you today. And by now you have attended so many sessions. And as I know, I think 2-3 sessions had been on access to justice. Right? But I'll try to speak on a different context. First of all, as usual, I always start with Sanskrit Shloka. Now, this Shloka is just what we are going to discuss, what we learn. We must imbibe it, and we must be benefited by it. Swasti prajabhaya paripalayantam nyayena margena mahim mahisha, which means may the well-being of all people be protected by the powerful and mighty leaders with law and justice. Now, this is related to the topic. If we are making a prayer, then this is related to the topic. Topic is access to justice, as he has already told you, justice to those who access it. Now, the key point here around which the whole issue revolves, that is justice. Can anybody out of you tell me what is justice? I don't want any particular definition. I don't want any particular view, but I want what each one of you understand by the term justice. Because if you understand this term only, then the question is, can we ask for access to justice as a matter of right? Aditya, आप और मैं same same आज बेटा.
We're not looking as difficult as you are.
वो तो बेटियों को लगता है ना. So, one by one, I just want your view on justice. The reason behind it is because you must be thinking, why I am this not a class? But you know, elders are always used to it. This few of you might have the liking of defining justice, and few of you may like to explain what is injustice. So that is why I'm asking you, one by one.
Give something what is due. Just
Absolutely right. Now that means you believe in the Justinian code.
Yeah.
So, fine.
if you look at law, I think sir has also taught us that access to justice is basically got law and access to court also when we talk about access to justice. So we are not
Access to justice, access to court. All right.
Yeah,
You
fairness.
note करते हैं ना, because I would like to touch.
Yes, ma'am.
fair resolution,
Clear?
resolution of a dispute.
Clear resolution of dispute. Note करो. Next.
Redressal of one's grievances.
Right. Next.
Okay, something which is fair, which can put two people on an equal page. Basically, it creates equality between two sides.
Fairness, being just and reasonable.
Reasoning. Reason comes into picture.
Ma'am. Equality before law, ma'am.
Equality.
This is the central pivot.
Anji. Finally.
Ma'am, it is something fair, just, and the person gets his due. And it's amalgamation of all these things. And at the last of this, if somebody is happy, then he has then he has get this access to justice, ultimate happiness and contentment.
Happiness. Yes.
Access to justice is related with the principle of natural justice. Because all of us talk about the fair, reasonable. It's all about principle of natural justice.
Next.
Justice is relative. Who has not experienced injustice cannot understand what justice is.
Yes.
It's a relative concept.
Absolutely right. Next.
Justice based on reasons, like decisions which are based on reasons. It seems like that justice has been done. It's not just only a book thing.
Widely acceptable, fair and reasonable ruling.
In practical sense, getting a favor in one's own cause.
Okay.
There's always this conundrum that law and justice might be the same thing, but I disagree. There are instances where law can also be unjust. So I feel that justice is not synonymous to law, and it is definitely wrong.
To define justice, but again, injustices are more easy to, hard to be defined than justice. But I believe equity is the reason.
Naditya.
Like Prithviraj, I would say it defies any definition. But if I had to put it in a modern context, I would say a mechanism or an outproduct of dispute settlement on settled principle. So when the principles are well laid, defined, settled, and on those principles are applied, the outproduct is justice in the modern context.
Shivali.
When something fair and reasonable, getting something for which we are actually entitled is justice. And
Entitlement.
when we are talking about injustice, when we are deprived of something for which we are actually entitled, that is injustice. Fairness and this just redressal of grievances also justice. And any kind of unfair treatment is injustice.
For me, the core idea of justice lies in reasonable fairness. And it is, yes, perspective based, as many of them have pointed out. For some, it may be reasonably given due. For some, it may be unreasonably taken away. It's perspective based. Most of
We'll be touching, he has noted, but I have found the majority opinion is towards fair and reasonable. This is the majority. I have to go back after turning the pages of history. What Plato said. In case of individual justice, he talked about human virtue. And presumption had been that man is good. And in case when we talk from the society's angle, then we talk about social consciousness, where there is a harmony. Now see, just if I talk about, because this clearly leads to the question of access to justice. When we talk about human virtue and we say we are good, if we are good, where is the question of dispute? If we talk about social consciousness and harmony, then again, where is the question of dispute? And how can we say that dispute settlement is justice? Now, this is questionable. Now, next question to you, because what is harmony? Now, I'll be approaching everything to this access to justice. Yes, please.
reconciliation. Even though there is some
Compatibility between two things.
And peaceful coexistence.
Very good. I love it. Anybody else? Something different. Anything different about harmony? I hope by now all of you know that I'm a poet by heart.
Yes.
So I'll proceed with this. You must understand what is harmony. Harmony is जब कीर्तन अजान गुरबानी प्रार्थना का हो एक सुर सप्तक. जब कीर्तन अजान गुरबानी और प्रार्थना का हो एक सुर सप्तक, एक ही जोड़ी में होते हो द्वार इनके, सामंजस्य सोता है थपक थपक. Do you understand the meaning of this? Now, what is this? Is it harmony? Do you agree with me? Further, now where lies the problem? We say, yes, this is harmony, and we may constructively follow it. And I'll be coming to that because when we talk about secularism, we talk about religion. Because this is, in fact, I agree with Amartya Sen also when he distinguishes between niti and nyaya. When he doesn't simply talk about some shortcomings of the society or the organizations of the nations, he simply talk about the behavioral issues among human beings. Niti is when we talk about any organizational propriety, and nyaya is at the same time my corrective behavior. Organizations, propriety, and my corrective behavior. This is niti. Nyaya is when, according to that, we get what is due to us. This is what he says. Now, for that purpose, and if you want to accede to justice, for proving it true, for making it a living reality, मैं अपनी जो पंक्तियां हैं उसके बाद की आपको बताऊंगी. जब अपने आंसू दूसरों की हंसी में खो जाते हैं, जब अपने आंसू दूसरों की हंसी में खो जाते हैं, दूसरों के दर्द में हंसते लबों पे नयन रो जाते हैं. I hope you understand. Now, this is what is in fact a harmony. First is we can show off, we can do it. Now in PJ Chandigarh, they are just the walls of the temple, Gurdwara, and mosque, everything is just adjacent. May not be the doors opening in one, only one part. But if you really feel for others, that's very important. And access to justice. And just leaving one question open, no doubt we have the justice delivery system. I think in one way or the other, we may talk about democratic countries or other countries, we have the system. It's not today, from the ancient times. But the question is that is it the desirable aspect in our life that we create disputes, then we approach and claim access to justice, and then we get justice. And then very, very important question is, can after this access to justice, status quo be granted? We are there only. From the point from where we started, the only satisfaction is I won the case. I got compensation. Perhaps. And this is a mortal satisfaction. But if we follow this, I think there won't be any issue. I'm again coming to that. Now, for this harmony, because when we talk about social harmony or social consciousness, and when further, if I talk about Karl Marx, who simply focused on economic justice. I'm not going into the details about all these theories. Economic justice. Now, what is this economic justice? What is this economic justice? Can we say all to be at par? Equal distribution of income? Is it practically possible? It is not. That is why we have to bring harmony or balance between what we say formal equality and informal equality. What is formal equality? Can anybody tell me what is formal?
Quality in the eye of law, but in reality.
Yes, Article 14 clearly talks about formal equality. And this is what Aristotle also said. Equals have to be treated equally, unequals unequally. Now, first part, if we talk about first part only, equals have to be treated equally. Then I think this cannot be absolutely taken as formal equality. But when I fight for that equality, because why I fight for that equality? Because I am in such a surrounding, in such an environment where there is inequality. So what is cherishable? What is desirable? That those surroundings need to be reformed. The environment should be such where we don't have such inequality. Now, of course, equals will be treated equally. Now, if you are working as a PN, you have equality among them. If you are working as the faculty members in a university or college, you must have equality among you. You cannot bring both at par. But the question is, when we want to accede to such basic necessities of life, access to justice. What is this justice? If I talk about when God made the earth, certain natural rights were created, all of us know. And now we are fighting for achieving those natural rights. Now, for that purpose, I would just like to talk about some types of justice. I will not be able to touch all kinds of justice because, every day the jurists, they bring out new forms of justice. If you read judgments of the Supreme Court of India, we find different kinds of justice. But and I want you to tell me any type of justice and let us discuss about that. And then how we can have access to that justice.
Distributive justice and corrective justice.
Yes. Now, distributive justice. What is distributive justice?
According to Article 39B(c) of Indian Constitution, natural resources.
Absolutely right. Equitable utilization of natural resources, equitable distribution of income. Now, 39B and C, these are the best examples of distributive justice. Now, distributive justice, we can correlate with even socialism, the socialistic character. Now, the term socialist, all of us know, was added in Indian Constitution in the preamble by 42nd Amendment Act 1976. But that does not mean India was not socialist prior to that, because we had this directive principles of state policy. And even I always correlate Articles 23 and 24 to this, because 23 simply talks about, then when we talk about no forced labor, no begar, no, this is relating to socialism. Now, in order to understand this distributive justice, then we must understand what is socialism from the Indian perspective. I don't believe in what the communist point of view on this is socialism, because then all sources, natural sources, all resources, everything is owned by the state. Now, this is not possible in the modern times. We believe in Gandhian perspective of socialism, where we have the blend of both private sector as well as public sector. Now, I would just like to quote a decision in 1997. There are a number of decisions, in fact. Samantha versus State of Tamil Nadu, or we can even talk about Air India Statutory Corporation versus United Labour Union, again of 1997. Now, see, distributive justice and socialism. Now, here Supreme Court categorically talked about raising the standards of the standard of living of people. Raising the standard of living. What would you call it? Formal equality or informal equality? Informal equality. And now the question is, which one is easier? Access to formal equality or informal equality? Now, equality, you only said this is one of the components of justice. Which is easier? Formal is always easier. Because why? Because wherever we go in any organization we are working, there are norms, there are rules. We go by those rules. And the moment rules are violated, we can file a petition. And even now I'm coming to the next point also. Because when we talk about access, it's not merely access, it's your affordability also. It's something which is time bound also. That's very, very important. Now, coming back to this, we claim as citizens of India that we must be protected from cradle to the grave. All the issues from cradle to the grave. The first thing, even though I'm not going to talk about the right of unborn child, but still, now can anybody tell me, forgetting about Transfer of Property Act, can you tell me, is there any right of unborn child directly or indirectly? Because we start from cradle, access to justice. Can anybody tell me? Property, absolutely right. Anything else? Now this is access to justice.
Causing the death in the womb of the mother.
Right to life.
Absolutely, wonderful, wonderful. And for that purpose, which act was passed?
PNP.
PNDT,
PNDT Act.
Article 21.
PNDT Act was amended in 2002, and pre-conceptual stage was also at
Included.
PNDT Act 2002. Anybody remembers any decision after 2002 where the apex court is still fighting to implement this act? Closure of those clinics where sex determination tests are going on. 2003 Sihat's case. 2016 Voluntary Health Organization versus Union of India. The Supreme Court simply telling, implement PCPNDT Act. Now we talk about now. Do you understand what is the meaning of this access to justice? Now here only, just taking a pause, because I just want to go back to the ancient times. Now, why we fail? Can anybody give me the reason why we failed? Why we failed or why we are failing? But we must be optimistic, we will not fail. Can anybody give me the reason? Yes, will. Will is very important. Jurisprudential, this will is very important. Whose will? Priority basis. Whose will? First of all, yes, absolutely right. Now, I'm just going to talk about what you want to say. What are the qualities of a king? Now, this was talked about in the ancient times. Even Chanakya talked about it. यथा दृष्टि शरीरस्य नित्यमेव प्रवर्तते तथा नरेंद्रो राष्ट्रस्य प्रभव सत्य धर्मयो, which means as the eyesight is helpful regularly for a proper setting in motion of the body, so also king is the cause of existence for truth and righteousness in a country. So that means we may not have the rulers in the same way. We may have different form of government. And once it is established that the state is a welfare state, we come to the same square. It is the duty of the state to protect us from cradle to the grave. Now, I take one side of this one, North Pole to South Pole, cradle. Now, if I talk about the grave, to the grave, again, it's really astonishing that we find a panacea for all kind of ills in the judiciary only. Why? I can refer to Aruna Ramachandra Shanbhag's case, access to justice, grave, a person in a vegetative state. Would you like to live that life? Would anybody like to live that life? So, in fact, this question was left open in 1996 in Gyankur versus State of Punjab. And Supreme Court did not approve of that. If I don't want to live, let me die. No, I cannot. And Supreme Court clearly said, yes, you have right to die, but with a rider, but only a natural death. Now here, the Supreme Court did not discuss the issue of euthanasia or mercy plea. Now this was brought before us in Aruna Ramachandra Sharma. Just imagine if you read the facts of the cases, what kind of life she lived. And see, here we start from access to justice and end at access to justice. She lived that life because there was no proper access to justice. Otherwise, this would not have occurred. And ended, and ultimately, she brought reforms in the system. And the Supreme Court recognized passive euthanasia, withdrawing the life support system. But the question still remained. Even the Supreme Court talked in detail the procedure, how the doctor's opinion, how the courts can intervene. But still, we should have a clear provision before us. How can I have access to justice when, God's sake, I should not, but I am reduced to a vegetative state? Then came the case of common cause versus Union of India. This was regarding you can make an informed will if you don't want to. Because we can't leave decisions to be taken by anybody else. Because then another issue of justice and access to justice will arise. Now, what will be that issue? Now, you read the newspapers and you read, father was killed by son for property. Mother was shot at because the mother stopped the son from taking liquor or drugs. Now, these are the conditions. Whether in these conditions, any old, infirm person can think of that he or she will have access to justice under those circumstances. So again, now we have the norms, guidelines, rules. We have these. And nowadays, I think there's no issue when we talk about judicial legislation till the passage of law by the legislator. Now, here only, now another issue has emerged. If I talk about this corrective justice, distributive part, still, I will be carrying with this distributive part also. Corrective justice, corrective is when I am harmed, I approach whatever system is there, tribunal, court, whatever the system is there, and I get my dues, the relief. Now here, number of questions are there. How much time it will take? I'm an old person. I have no one to maintain except my son and daughter. And my son and daughter, they refuse to take care of me. First is natural justice, not in terms of administrative law, in terms of the God-made justice. It is the duty of my son, my daughter, to look after me, to maintain me. And even in Hindu law, we talk about pious obligation of son. Now, the problem part, this is the cultural aspect. certain customs also play a very important role. I will look towards my son only. That my son should look after me. But if I don't have a son, we have brought up our daughters in such a way, not today, but in the ancient times. कहते थे पराया धन है, दूसरे घर में जाएगी, वहां माँ बाप की सेवा करना. And then you look towards your sons that they will maintain you, they will take care of you. Now, if you don't have a son in the modern times, then what to do? Daughters, they refuse to. I'm reminded of a decision of Supreme Court in 1987, Vijaya versus Kashi Rao. Supreme Court clearly said it is obligation of even a married daughter to look after the parents. Now this is access to justice. And then this act was passed in 2007. Now here, it's a very, very important question. We always talk about speedy justice. We always talk about speedy justice. But we talk about speedy justice not at the hands of the courts, speedy justice even at the hands of the legislature, even at the hands of the executive. Do we talk? Nowhere. That is also access to justice. One person is drowning and he's crying for help, help, save me, I'll get drowned. I go and tell him, sir, look, there is no law under which I can come and save you. So let the parliament sit in session, frame a law, I'll definitely come. I'll perform my duty to save you. Now, this is the scenario, this is the picture. We sleep over things. And we have examples. It's not that we don't have examples. I can give you the example of 1984. 1984, Lakshmikant Pandey versus Union of India. Now that was the situation, the facts, people from abroad coming to India, adopting children, taking them there, and exploiting them like anything, giving cruel, barbaric, and inhuman treatment to those children. Imagine we did not have any law. And the shackles in our hands that no court can direct the legislature to enact any law. No court, even if law is there, no court can direct the government, the executive to implement those laws. And complete guidelines were given by the Supreme Court. Now, access to justice. We have never touched this area. We always talk from the angle of so many cases pending before the courts. Could my petition was admitted or not? How many years it took to deliver justice? But do we talk about how many years it took to frame laws? 1984 guidelines for inter-country adoption were issued by the Supreme Court. See, CARA guidelines came in 2016, after 32 years. Where is justice and where is access to justice? And same example we can talk about when we talk about justice to whom? Justice at which level? The moment I say justice to whom, suppose I ask you, justice to whom? Yes. Justice to whom? There can be different answers. One will be very abstract answer. One will be very clear answer. I'm expecting all the answers. Justice to whom? No, agree. I am aggrieved. But I don't prefer moving the court. I'm really aggrieved. But I said, I can't. Now, number of situations. One situation is, I'm a Pardanashil woman. I'm an illiterate woman. Who will allow me to go to a court of law? I have not crossed my threshold I don't know where to go, whom to meet, what to do. I am deprived. I'm very poor. I know I'm suffering. I'm very poor. Instead of paying hefty fee to the lawyers, I prefer spending that amount having 2 square meals a day. What can we say? Justice to whom we talk about them. Find out some suitable word which we can use and talk about and say that they need access to justice.
In fact, institutionalism promoted very formal aspect of justice. We are talking
Formal aspect of justice. Yes, we don't get formal. I'll be touching formal aspect of justice also, don't worry. I'll talk about
Justice seekers, ma'am.
justice to whom?
Seekers, who are seekers here?
Not seekers, who need justice. Seeker. I said I'm a Parthavishi woman. How can I seek justice? Nobody will allow me to cross the entry of my house. Simply, we say many a time we use the terms, we say vulnerable section of the society, marginalized section of the society. Now again, that question of access to justice, when I talk about like in relation to women, being a female, it is very, very difficult to digest for me to say that they still need justice, but this is the bitter reality. And again, if I give you the same example, I hope you know about Mathura case, all of you know about Mathura case, what happened. If I talk about Rupal Jose Bajaj versus KPS Gill of 1995, what happened? We did not have law. But because she was well educated and she was IAS officer and she would fight till the Supreme Court in view of the provisions of Indian Penal Code only, and she won the case. I remember one situation, I don't remember the name of the case. Victim was air hostess in one airlines. Yes. Not Nagesh Mirza, not Nagesh. There is one more case. This was some Arabian Airlines or something like that. This is something different. That is something different. That is case of formal inequality. Now here she filed a complaint of sexual harassment. And she was terminated. On the ground, this was maligning the name of the airlines. Now, access to justice. Even if she tried, she did not get. And then came Vishakha versus State of Rajasthan, all of you know, 1997. What was the objective? Justice to victims. So this is kind of justice to a vulnerable section of society who might not have come forward, and perhaps the pangs of Mathura were still echoing in our ears. This was the reason. Vishakha, this is the best example of judicial legislation. Complete code was given by the Supreme Court. Everything regarding what amounts to sexual harassment, what should be done for prevention, redressal, and everything was there. Who will tell me when the act was passed? This decision was in how many years? 16 years. 16 years. We can hope. After 1 year, after 2 years, 16 years. This is not the only example. D.K. Basu, 1997, and criminal law was amended. Just imagine. And then we have two schools of thought. One says, no, judges cannot make law. Judges should not make law. And when we talk about access to justice, this is brought before us. And if I just refresh your minds, I hope you might remember those are from the area of family law, especially. Madhu Kishwar's case of 1996. I think Madhu Kishwar versus perhaps State of Bihar. Remember, tribal women did not have any right to inherit property of father, property of husband. And this was only done, I think, in 2005 or 2005. How many years? Again, 8 years. We want to count years from the date of the reporting of the decision, but just imagine for how many years they had been suffering. That's very important, right? And number of other issues, if I talk about here, coming to different kinds of justice. Corrective justice. Corrective justice also, see how much time it took place changing the theories of punishment. Because access to justice, I am the victim. There was a time when I used to think that I will get justice only when the accused is punished. Changed. You open the statute book, you even open the constitution. We have the provision where we talk about safeguards available to the accused. Article 20 and 22 and even 21. 21 we talk about, right? And even so many Supreme Court decisions where we may talk about Nandini Satpathi's case. We may refer to all those cases where the Supreme Court wrote the present jurisprudence, mainly for the accused who are convicted. Their welfare. The whole present jurisprudence was written after mainly Sunil Batra 1 and Sunil Batra 2, 78 and 80. We know, and so many cases. Right? When we started thinking of the victim, when Amendment 357A 9. Just imagine. Access to justice we talk about. We talk about justice. We talk about justice. This is restorative, another kind of justice. Now, restorative justice. And in fact, we are really progressing towards what is desirable. It is not that we always get relief by punishing the accused. Accepting those who are hardened criminals beyond reformation. And this is what the new phase of restorative justice, where even we talk about having interactions between the victim and the accused. And ultimately, we reach to some kind of, because that gives a satisfaction to the victim and that gives the chance of repentance to the accused also. Because ultimately, gone are the days when we used to talk about the deterrent form of punishment or retributive form of punishment. Now, crossing the threshold of reformative justice, we have landed into restorative justice. Now, restorative justice, in fact, is the major and most precious component of corrective justice. And then, very important thing I would just like to refer to, a distinction which we need to make between what we say conservative justice and ideal justice. Conservative justice. Conservative justice, the existing norms, existing laws, and moral values. Ideal justice is justice which is required in the present scenario, where we need even changes in the laws, changes in the application of laws. Now, what is very, very important? Can you give any example of any law where we find place for values? Fundamental duties, fine. What else? Anything else?
Hindu adoption and maintenance.
Maintenance laws, duty. Absolutely right. Even Senior Citizens Act 2007. Any? That's right. Anything else?
Adultery was struck down. The idea of adultery also involved what value.
No, that's fine when we talk about the Hindu laws, even when we talk about Shaira Banu's case, even when we talk about Shah Banu's case, we find place for values. That is why the total change was there. Now, it's not merely maintenance under the Muslim law, but even the, yes, 125 CRPC. Same is true about Shaira Banu, where personal laws are tested on the touchstone of equality, access to justice. This is access to justice. But still, the question remains that value from the angle of the society, value from the angle of law. We can have line of demarcation. Can you distinguish? Still, even though in 2014 Supreme Court in National Legal Service Authority versus Union of India talked about rights of transgenders, even talked about reservation for them. And now in every form you find male, female, third gender. The question is acceptability by the society. That's very important because no law can be implemented unless and until it is acceptable to the society. And we have the best example of dowry prohibition law. We failed. Miserably we failed. So many laws we have really failed. And now we are talking about these. I hope you can remember what a stigmatic life the transgenders had lived. तो आज हम कहते हैं ना ट्रांसजेंडर तो सब हिजड़े ही कहते थे उन्हें. Same is true about LGBTQ. Now still the question is open. Have we accepted? No, we have not, even though the judgment is there. So where is the access to justice?
Cannot marry.
Where is access to justice? That's very important.
India may look for mercifully.
Yes, still temples are there at places. Still temples are there. People go and worship. And still as good omen, people go there. Mannat mangte hain jaake. If you, yes. Now this is in fact the mockery of the situation. That we have not accepted. Until we accept, now can there be real access to justice? I'll certainly take a U-turn and say, before having access to justice, what is required? Access to yourself. अब समझते access to yourself का मतलब? Can anybody tell me? क्या मतलब है? If I say I must have access to myself, क्या मतलब है इसका?
Self-knowledge or
Introspection.
self-realization.
Self-realization. Now, if I give it spiritual touch, then relationship between the body and the soul. And what is soul? We have not seen. But I think one thing all of us understand that there is something consciousness, our conscience. At least we can look into our conscience. But do we have access to ourselves? If I ask, how many of you daily do introspection or weekly do introspection or monthly do introspection? I think none. We let anything which has occurred as past. We don't. And that is why history repeats. That is why the question of access to justice arises. Next question is access to family. Do you have access to family? Yes. Now, what do you understand by access to family?
Family means like something we can share with them, with others. Anything which we want to share with them.
मम्मी कहती है आज मेरी तबीयत बड़ी खराब है, तो बेटा कहता है दीदी को बोल दो ना मम्मी आज छुट्टी ले लेगी. Is this access to family? Is this access to yourself? क्या कहना चाहिए बेटे को? हाँ, यस, आज मैं छुट्टी लूंगा मम्मी, मैं घर पे हूँ. और क्या आप ऐसा करते हैं? नहीं करते हैं. You take your mothers for granted. मम्मी तो कभी बीमार हो ही नहीं सकती. And then I come to access to society. Then comes into picture all these issues. See, on the one hand, you say, you know, my report card is in the university. If it is shown, my mark sheet is shown to my class fellow, my privacy is violated. And I click the picture and put it on Facebook. Then my privacy is not violated. And नहीं, वो मार्क्स वाली साइड नहीं ना, दूसरी साइड दे देंगे कि यहाँ से पढ़ रहे हैं, यूनिवर्सिटी से पढ़ रहे हैं, वो पिक्चर आ जाएगी. मार्क्स वाली नहीं आएगी, अपोजिट साइड आ जाएगी जहाँ सारे क्राइटेरिया दिए होते हैं. Now, don't we have any duty, access to justice when we talk about? If we collect the data of suicides committed in the society on any issues. No, don't you think they also had a right to access to justice? Because now Supreme Court, this is settled even Anita Kushwaha versus Pushpa Sadan, that access to justice is a fundamental right now. Fundamental right. Can you say they did not have right? Unfortunately, they cannot have any recourse if they committed suicide. इससे उल्टा क्या होता कि जिंदा रह जाते तो वैसे पनिशेबल था. अब तो बच गए, अब you try to commit suicide. So just, yeah, yes. And especially when we talk about right to health, which includes even mental health, when we talk about right to privacy, where is the privacy? In fact, credit goes to Shreya Shingal's case. You can publish anything on the internet which may hurt anybody. So everyone has this right to access to justice. We can take a number of other examples. The Supreme Court always played a positive role. If you can remember the case of John Walmaton, 2003, do you remember that case? In question was section 118 of Indian Succession Act. What was that?
Some Christians were not able to donate the land for the purpose of charity, kind of.
It prohibited bequeathing of personal property for religious purposes if near relatives were alive. I don't know whether you read it in depth or not. And the near relative did not include wife. when we say there is access to justice, wife's right to access to justice. वाइफ जिंदा है सारी प्रॉपर्टी रिक्वीज कर दीजिए, लेकिन आपका भतीजा भतीजी कोई जिंदा है तो आप नहीं कर सकते. And then the provision said the bill should have been made at least 12 months before time. मैं तो नहीं कर सकती, शायद आप कर सकते हो. And we talk about justice and access. This is and similarly, if I just refer to again, you can read that Daniel Latifi's case, that book 2001. That is, I say, why there is a gap between the framing of laws and why there should be a need that such guidelines are issued only by the courts. Here, Supreme Court clearly talked about that if the husband fails to maintain, then the relatives will still there is a gap. We read the judgments in the reporters. We are quoting the reporters and we are appreciating the apex court. Do we have the data whether there is implementation of such decisions? Because again, we need application of law. So, question of access to justice remains. When we talk about speedy justice, affordable justice. Now, affordable justice. Can I afford? May not be. Note of appreciation for amending the Constitution, adding Article 39, capital A. It talks about free legal aid and equal justice. Number of decisions by the Supreme Court. The state of Maharashtra, all of you know, 1978. Then even Supreme Court talked about the duty of the magistrate to inform that you have a right. Appreciate the Supreme Court. There are a number of not going to details of the legal. Then, even if there is free legal aid, a number of issues on original basis. What's in find in the urban area? They are depriving the rural. Although Gandhi had a dream of Gram Nyayalayas. And when this act was passed, I think 2009. And just recently, again, the Supreme Court, I don't remember. Case in 2020, Foundation of Spiritual Justice. And the Supreme Court had to issue guidelines working out these Gram Nyaya. And beautifully, Supreme Court talked about the value of having these Gram. One is affordable justice. Second is speedy justice. Next is the physical access of justice to rural. And in fact, we are very, very fortunate even after the passage of Legal Services Authority Act 1987. Again, this access to formal justice when there is a dispute that becomes. And then we need to talk about even the natural justice. The two angles. One angle I touched. Actual right. I must get food to eat, clothes to wear, shelter on my head, and we are human beings. So we need to get married for actually see what extent we have access to this. Can anybody tell me what extent? Why we both had to interfere for ensuring this access to? Can anybody give an example?
Javier says,
Right, right. Here today, 2006, we talked about Lata Singh. Court had to say that you have a right to marry person of your own choice. And even the Arihugam Sirvai Supreme Court condemned this 2011 honor killing and roll of panchayats. No, but this is the problem. I talked about access to society. Similarly, limits of access of society to do. When in question is this concept of right. Similarly, here only I can refer to when we talk about this kind of life. I can refer to I want to live. For living, I need meals. I need bread and butter. But nobody is going to. I'm not a capacity that I'll go for Viksha. I have to cook it. If I don't get any employment, because we know it's not that it's sure that you will get employment. Let's look down. In spite of the fact, into this Immoral Traffic Prevention Act, clearly says prostitution per se is not enough. Still, we look down on them. They have access to justice. And we have the decisions like there was a decision of Kushalya versus State, where the directions are given by the Supreme Court that all the prostitutes they have their houses, their residences on the outskirts of the and we call that area as the red light area. So what they are doing, they are also carrying out a profession, they are earning. And again, a note of appreciation that their right to access justice, Buddhadev Karmaskar's case of 2011, where the Supreme Court recognized the rights of sin.
Also, now in Madhukar Narayan case,
Madhukar Narayan's case, when the police officer he wanted to have access to some prostitute, he put paper that even these females of easy virtue have right to privacy. This is real when we talk about access to. I have my autonomy, my identity. So, even though we may say majority of females sitting here, that we are empowered. All of us are involved in constructive decision making. And that decision making may be whether I want to reproduce child or not, whether I want to conceive a child or not. Can a female take a decision? But even the Supreme Court has talked a number of cases. I can refer to Srivastava versus Chandigarh decision of 2010. But still, practically, what is the situation? Question of access. Forget about everything. You are in service. And again, most of the times we have to fight. If we don't need to fight, why we have Article 16 under the Constitution? When we talk about equality of opportunity in matters of appointment and employment. this justice out of appreciation for the Supreme. Even though when we read Article 16, Clause 2, it talks about no discrimination on certain grounds, and one of the ground is I cannot claim, and no office can make a reservation that the children of this cadre officer will be appointed on the basis of that they are children of. This cannot be done because this is violative of this dissent. If we want to make this access to justice as a living reality, we for innovated the concept of compassionate force within the limits. So we know right is happening. Even compassionate department cannot be exercised as a matter of. The objective is only to help the penurious family under rules. And the only bread honored them. And similarly, when I talk about the natural justice, the other part of the natural justice, what you said, or as you said, fair and just. Whatever decision is taken has to be fair, just. In fact, when Adam and Eve take the prohibited fruit, God gave in hearing. Take that prohibited fruit, then there was inception of life. And very good distinction if you want to make, looking at natural justice principles between formal and informal equality. He talks about there should not be justices and access to justices when lion and lamb they drink water in the same informal. In the great article of 39, you can see this situation and which will never become it. And there is another kind of justice which is covered under this natural justice, which we call as the substantive and procedural justice. Procedural justice many a time is more important than substantive justice. The law is there, but when we talk about application, that application part has to be fair, just, and decent. Natural justice. See, different situations. One situation is that I am hurt. My rights are violated. I am the victim. I can knock at the door of the court. Well, when we talk about administrative law principles, Mr. X is a worker. He hits his superior. Superior is hit. So but he cannot take any decision, even though he is a sufferer. He knows how he suffered. This is natural justice. Why? Because we have to put on the balance the rights of both the victim as well as the perpetrator who committed that. So that is why we talk about very important principle of natural justice, that nobody should be a judge in his own. Then one fine morning you reach your office. On your table you find a letter for subsequently terminated with immediate effect with a check of 117. Reaction? You say, no issue. I've got the salary for 1 month. I'll go find out another job. What would be your reaction? Let me know. Give me reasons. Why? You talk about reasons. Tell me reasons. That why I'm being shutted out. Give me chance of representation. This where reason comes into picture. Here you and the reason. One thing is give me reasons. Second is whatever you do is reasonable. Whatever you do, whatever decision you take, there is plausible justification for that. Now, this is another example. When in a welfare state, your expectations are more, and due to your expectations, so many disputes and conflicts are there, and those need to be settled. Now, how these will be settled? If state is one party, if it is state versus X, then the state is superior, always superior. Even though you may sing the sonorous song of social contract theory, that this is me who entered into a contract, that I submit all my life, my rights, my property to the ruler, that you will look after me, you protect my life, you protect my property. You, the Rousseau may say that you can do what? Yes, we do in a democratic system. And Himachal में एक साल कांग्रेस आपकी एक साल बीजेपी आपकी because of Rousseau's advice. Now, you just let me know that under Rousseau's, what is reasonable? What is reasonable? क्या reasonable है बताइए? बात स्टेट और हमारे मेरे बीच में है. बताइए what is reasonable? There is the question of that exercise of power. State क्या करेगी? Power exercise करेगी. Can power be absolute?
No.
Lord Actor very rightly said, power corrupts. Absolute. और मैं थोड़ी सी कुछ और कहती हूँ. मेरा ये तो I agree with him, but I further say liberty corrupts. Absolute liberty corrupts. That is why we talk about reasonability. Just talk on the one side state, on the other side persons. Power to be broad, liberty to be curtailed. Right? Now, power. Then sometimes you think, no power vested. I don't have access to justice because of the power being exercised in a wrong way, power being misused, abused, exceeded. Then what to do? That means we have to prescribe the limits on the exercise of. So if I want to access to justice, कुछ नहीं है, मुझे अपना birth certificate लेना है, and I am going time and again to the officer concerned, and I am not getting my birth certificate. This is my right. I have submitted all the papers. That means the issue is in the exercise of function, the exercise of power. Then I feel why power is vested. They cannot exercise. In fact, we have number of decisions by the Supreme Court. If power is vested, you have to exercise. And the way it is prescribed, you have to exercise. And go beyond the scope of what is your power. Simple words, we talk about there should be plausible justification. Exercise. Power invested in me. मैं बहुत ही हो सकता है बहुत ही डरपोक हूँ. एक गलती तो हो सकती है. गलती तो नहीं करनी. Question is that of justice. Question is that of access to justice. Then I will be the culprit that I used the power in such a way that I did not do justice and the other person did not have access to justice. That's the power exercise. So Can I do it? No, I had to. Then this is one thing, but second is in the present scenario, and as a citizen, not as a resident of the sector, nor the children of any parent, nor a parent of any child, nor the wife, nor as a daughter, as citizens, when I talk about access to this, then my expectation is that the open of the concept of if I want to have, you can have access to justice about the facts for the patient's information. Transparency. Sunlight is the only department. This is very important. And only then you can access to justice. And another component comes into picture that I must have a right to participate in the rendering of पुराने जमाने में jury system. And still, in between, there was some decision of Supreme Court and the family courts also some kind of jury they started with for some years in between. And we have, again, we have different forums, Lok Adalats, where it is not that only judges are sitting there. One person who can understand. And in fact, just 2 days back, I was in some lecture in some panel discussion, and somebody talked about that of the role of the IT people, basically, because of now after COVID-19 pandemic, AI and machine learning is there, everything is online. I really thought that means by having clear access to justice, then we need judges also as experts in different areas. Now, I can't forget the Supreme Court talking about the green judge, green bench. Then we have NGT. And now days are not far off if we want real access to justice. The issues are being changed with the passage of time. And once the issues will be on the cyber, issues will be regarding the AI or machine learning. I don't know anything about it. Even the judges sitting on the bench, they won't be knowing anything on the bench. So immediately comes into picture, we have to create that platform if we want to have real access to justice. That means creating learning, creating awareness about the laws, about the principles of justice. Now, and that can be started from the root level. What is the root level? Yes, me. And then it will come to you. So then that means first I have to reform myself, and then I can pick up you. And I can as elder, I can then deliver sermons to all of you. Any question?
Thank you, ma'am. I have a small question, ma'am. Ma'am, you have suggested that our all focus is to try to reform the question of access to justice from the perspective of court-centric or a state-centric. But we have to go beyond that, and we need to investigate social-centric or cultural-centric or a spiritual-centric, I would say. That would be more beneficial to answer this question.
See, even the courts, they are talking from this angle. If I just refer to Lieutenant Colonel Nitasha versus. Before that, all of you know about the Babita Punia's case, any Rajan's case. For the first time, Supreme Court talked about Rani, Army, Navy. But then when practically it started taking shape, and I can say that they asked for access to justice. Then came into picture the whole scenario why they lagged. How their ACRs were written, what was the competency criteria? Females to compete with the males. Even the law of nature is different. And this kind of contention was there. Strong contentions by the state against this permanent commissioning. Females cannot because of physique, because of this, because of that. Now here, Supreme Court innovated, we had been talking for years together, no discrimination, there no arbitrary exercise of power. Even better principle, doctrine of proportionality, everything now Supreme Court, District Judge in fact beautifully talked about indirect discrimination. Said this is not merely a component of discrimination, but a tool for discrimination. And in order to deal with the discrimination, we have to go beyond. Merely declaring something void or unconstitutional or awarding compensation. We have to go beyond that. Now, taking a pause on what you are talking about, how important society are. Supreme Court long back in early 19, but Justice Chandrachud talked now in 2021, the Supreme Court in the early 90s talked about this. My question. First, I give you an example. One fine morning, you receive a letter of termination. Go to a court of law. And it takes 8 years. Instead of the fact that speedy right to speedy trial and fundamental rights, to be say Kadra Padia, so many cases, even I ran into 2001, Anil Rai, State of Bihar, where Supreme Court even gave the time period within which the judgment is to be delivered. 2 months, if beyond 3 months, you write, it has to be considered. Still judgment is not delivered. Then after 6 months, change the bench. No solution. And 2020, I still remember, court talked about the judgment, which is given by copyright. So many months, and you think you will get? But not. To get years. Then Supreme Court nearly questions the freedom of the university is absolutely wrong. I said this. We lost so many questions. Years after. Then trend came. Supreme Court started awarding exemplary cost, compensation, compensation. I'm not certain. I'll lose it. Fine. The reason? Yes, justice was it's not merely access to justice. I repeat, it does not merely mean access to court. Means when you get your due, when you get the relief. And it's not merely court's relief. It's social relief, it's cultural relief. आप ये सोचो कि आप घर बैठ गए, किसी ने नहीं देखना कि गलती किसकी थी, आपकी की नहीं थी, उन्होंने नौकरी से निकाल दिया. और mental health issues beyond restoration. आप सिर्फ justice की बात मत करो, मैं तो ये बात करूँगी कि just imagine status quo cannot be transferred, कितना मर्जी compensation. And secondly, from where you are getting compensation, have you ever given a thought? I am a taxpayer. I am paying and out of state exchequer this compensation is being paid. I paid and I am getting it back. Who is paying? It will be real justice. Justice is, if you have done a wrong, you must pay for it. The Supreme Court developed the concept of fixing personal liability, paying compensation and recovering out of the pockets of the guilty. Number of cases. I can just refer to G.N. Pajuria's case of 1995, where Supreme Court went to the extent of saying that if you misuse the power, then you must face the consequence. Now, just see. Now, here there's a social. first situation was wrongly action was taken against me. I was targeted. Stigma against me. Now, who committed the wrong will be targeted, and I think fact, this has the real, this is the real preventive measure. When your own community uses. Now, this is the. Yeah?
Yes.
Thank you.
Any other question? I think
It's more on philosophical aspect, man. Not we as a country, India as a country, or across the globe, do we fail to translate human resource by the action of inclusivity? So that, if we have a lot of people, lot of mind, we still fail to actually materialize. For example, access to justice, concept of access to justice. One mind cannot come up with definition. But if we can bring a lot of minds together, they can come up with a better system. Even we talk of concept like deliberative democracy, or we fail to have this principle of inclusivity in the justice system. So every time we leave, one person dissatisfied, not one person, thousands of persons dissatisfied. So my question is more on this, ma'am. Why, as academicians, the right things don't come up, which talk of bringing everybody together and streamlining things and the rule of inclusivity, not part of democracy.
It's very, very important. In fact, I always conclude nobody on this earth can, no law can, unless it. When I cross the red light, this is my faulty. Even if there is nobody on the road, it's required, I must stand there. Because otherwise, I'm violating other person. But we don't know. From the other side of the road, where there is green light, he or she on the right. And then there's every chance of it. That means because of my fault, I am violating other. And this is not we talk today. In fact, we always talk about the right, every right has a correlate. And you can exercise right only when the other person is the problem. And then when most of the time when we talk about any distributive justice or economic justice or social justice or political justice, everywhere, in fact, we cannot clap with one hand. But we have to point why we accuse any abstract identity or any abstract existence like state. State क्या है? आप देख सकते हो स्टेट को, छू सकते हो स्टेट को, स्मेल कर सकते हो स्टेट को, मेजर कर सकते हो. टेरिटरी नहीं है कि उसको मेजर कर लोगे, वे कर सकते हो, नहीं कर सकते हो, but still you feel the pressure. State is formed of view. Government is formed of view. ना तो बीरबल अकबर को भी कहानी है ना, अकबर ने कहा कि बीरबल को सबको कहना कि इसमें एक गड्ढे की डाल के आना, सभी पानी डाल गए, मेरे पानी डालने से क्या होगा, बाकी दो डाल देंगे. This is the problem when we lack it. This is the philosophy. See, this philosophy starts from home only. That is why I talked about access to me, access to family. तो फैमिली की रिस्पॉन्सिबिलिटी होती है. जब माँ ने जाना होता है पार्टी पे, हाँ जाती है तैयार, बच्चा कहता है मम्मी मेरा तो होमवर्क रहता है अभी, कोई नहीं बेटा कल जाके कहना मेरा पेट दर्द हो रहा है तो मैंने होमवर्क नहीं. क्या है this is how we bring up our children. We prepare them to tell lies. तो यही इफेक्ट करता है बाद में जाके. रोड पे जाके जा रहे होते हैं पापा, जब रेड लाइट क्रॉस करने लगते हैं तो बेटा कहता है पापा मेरे को भी टीचर मैम ने बोला था कि आपको रेड लाइट पे स्टॉप करना है, आपको येलो लाइट पे स्टार्ट करना है, आपको ग्रीन लाइट पे क्रॉस करना है. व्हाट आर यू डूइंग? This is where we need to bring the and each one of us. अगर मैं सोचूं कि नहीं ये बदल जाए तो दुनिया बदल जाएगी ऐसा. Yes? Anybody else? Don't leave the section with any doubt in your mind. See, my way of speaking, my way of talking of any concept. I think you could have made the papers upwards as to this. I don't talk in those terms.
We see the reverse happening in India. We've been seeing with successive financial bills, all these tribunals that were set up with experts, now they're being either clubbed or shut down. Then how do we get access to justice in real terms? Because most of these judges are not experts.
There is a solution. There is a solution. That solution is, now we are moving towards that solution. No, nowadays law is being taught even to the seniors, the scientists, and this is the need. If आपका कोई भी issue होगा cyber crime का, so judges cannot help you unless until there is proper forensic issue है, so forensic scientist is required. So everyone needs to understand the basic stuff. ये पता होना बहुत मैं आप लोगों से यही बात शेयर करूं. Few years back, I was in Punjab University at that time. I was sitting in some committees of issue for there. तो ये जो law के नहीं होते, there was some senior, very senior professor. I had just become professor long back, 22 years back. And मैडम आप बताओ आप law के हैं तो हमारी आदत तो थी मैंने कहा स्पीकिंग ऑर्डर पास कर देना चाहिए. मेरी थी कहना चाहिए order. And he said, no, ma'am. It should be written order. अगर आप ये सिखाओगे तो प्रॉब्लम नहीं होगी.
Thank you, ma'am, for giving us time and also giving so much insight on this particular issue. We are really honored to have you here. Thank you so much.